All right, Chapter 7, Ethics. So you hopefully use this chapter earlier when you're writing your short essay. All right, ethics codes. I have put in your extra materials for this week a link to the actual rules of professional responsibility for California. And they're the ones that apply to paralegals and lawyers in the state. If the rules don't talk about something, then and only then the American Bar Association model rules would apply, which is what pretty much your book was talking about. All right. There's kind of a balancing act that goes into being an attorney. And that is, on one hand, I'm an officer of the court, and I'm not supposed to lie to the court, and I don't have quite the onus put on me as maybe a district attorney, but I'm not supposed to help my client lie to the court. And on the other hand, I have zealous representation, which is, do everything ethical, legally ethical within my power to get the result for my client that they would desire. All right. So lawyers have to be admitted into each court, and we mentioned this earlier in the slides. So if an attorney is admitted to the state of California, they can practice in all California state courts. But each federal court pretty much has a separate admission. So I showed you the copies of my Southern District and my Central District. And I didn't bother with Sacramento or the Northern District because most attorneys in California decided to practice in the Southern part of California or the Northern California. Because the rules are very different between the two, and even the jury verdicts are very different. So usually attorneys pick. And I know some of you are thinking about going and taking the bar exam, so I've given you a website that you can click on from your regular PowerPoint. All right, attorneys also have to be morally certified. So, for example, I had a friend in law school who had 14 DUIs. 14. And he wanted to become a lawyer, and he did not get admitted to the bar because they determined that 14 DUIs was not legally moral. And this is different morals than maybe you have, or different from your religious beliefs. These are legal ethics. So we're saying as a society that we don't want to have lawyers that have 14 driving while intoxicated convictions. The attorney is supposed to be ethical, and 1 or 2 DUIs probably won't keep somebody from being an attorney. Going back to the last slide, the court doesn't usually want to see an attorney who's written bad checks, told some lies under penalty of perjury. So they're just checking the whole background. All right, moving on to slide 7. Now, attorneys have to pay to be an attorney in the state for the most part. And that's typically anywhere from $800 to $1,000. And it depends on whether the attorney decides to give some money to different charitable organizations. Okay, and then attorneys have 25 hours every 3 years that they must do in continuing legal education. And paralegals, for those of you that are in the paralegal program and plan on graduating, once you're done, you're going to have to do 8 continuing legal education hours every 2 years. And 4 of those have to be in ethics. You can do about half of your total continuing legal education by reading and taking an exam, which is known as non-participation. And the other half, you typically have to go to some sort of lecture. Okay, we already talked about this slide, so moving on. All right. American Bar Association Rule 6.1 is perhaps the most ignored rule in ethics, and that is that each lawyer, and this applies to paralegals as well, there's lots of cases that say that, and each lawyer and paralegal is supposed to volunteer 50 hours of free legal services for a year. And I went ahead in your extra materials let you know about some other volunteer opportunities. These aren't required, but it's a great way to go ahead and get yourself some experience on your resume. And I will be posting some other great volunteer opportunities, which include filing parties. The courts are so backed up in all their paper filing that every so often they post opportunities to come and help file, and it's a great way to network. I post that on the Blackboard All, so hopefully because you're taking a paralegal class, you're getting those announcements, and you can volunteer for that if you so desire. Okay, so the State Bar investigates when there's allegations, often made by a client, that the attorney is acting unethically. And typically, disbarment does not last for the lifetime of the attorney. Typically, it's for a 10-year period, and the attorney can show good behavior during that 10 years, and then apply to be reinstated. Suspension probation is typically for a shorter amount of time than 10 years. And resignation with discipline charges pending, they might have a criminal case against them, so they decide to voluntarily resign their status as a lawyer so that it's like a plea agreement sometimes. They get out of having to go to jail or paying fines. And attorneys can also get in trouble for not doing those 25 hours of legal education, not paying their dues. So they can be unenrolled or become inactive for a different variety of reasons. And you really have to look at that website I provided you last class, the attorney discipline, and see why the attorney is in trouble, and see if it's a big deal, such as some like sexual impropriety with the client, stealing the client's money, or if it's something comparatively minor like not paying their dues on time. All right, the attorney can also be up for criminal prosecution. Unfortunately, sometimes clients and attorneys engage in legally unethical sexual conduct. If the attorney is doing something that bad, he or she might be up for criminal violations. Embezzling client funds can definitely bring a criminal case against an attorney. And we've mentioned this before, but one of the biggest things that new attorneys get in trouble for is they do not realize that retainers need to be put in a separate client trust account. It does not go directly into their own bank account. That is money, that's the client's money, and it's put in a special account for them, and we only take the money out after we've done the work and sent out the bill. Another thing that attorneys get in trouble for, and this is the thing that established attorneys get in trouble the most for, is not keeping that client contact. And it's usually like for 9 months or a year, no emails, no phone calls, no letters. That can get an attorney in a lot of trouble. All right, moving on to our zealous representation. I have to always put the client's interests before my own. I am supposed to do all that is legally ethical to help them win their case, but I'm not supposed to do anything illegal or legally unethical to help them. All right, so you are actually licensed, and you can be certified by a special like National Association of Legal Assistants, National Federation of Paralegal Associates, but basically it's a license. And here is to read on your own different paralegal certification exams. All right, legal malpractice is brought by a former client against their legal team, and she's basically saying that had the attorneys been not negligent, then I would have won my case. And it's very common, especially when the economy's doing bad. People get upset that they don't win their case, and they go find an attorney to sue their prior attorney. Okay, so legal malpractice is basically negligence just fancified, if you will. Fancified? Okay. So there has to be an attorney-client relationship, and that duty is breached, and that breach causes the client to lose their case or get less money as a result of that negligence. All right. Another thing that attorneys have to have in order to properly represent the client and not have a legal malpractice case against them is they have to be competent. And this means that if I'm an immigration attorney and I get asked to do a family law case, I can do that family law case, but I need to get up to speed on family law so that I can do the best job possible for that client, just as if they had gone to a family law practitioner, the person that normally practiced that. Confidentiality is a huge issue in law, and I like to call it client confidentiality or attorney-client privilege. It's not just, like the picture, whispering into somebody else's ear and don't tell. No, it's actually at the point where anything negative that we hear about the client, we're really not supposed to repeat, even if we read about it in the paper. Again, this kind of goes back to and hand in hand with zealous representation. We're supposed to be very pro-client and not be talking negatively about them or revealing the confidences that they made so that we can provide them the best legal services. All right, so ways to avoid legal malpractice claims are definitely communicate with clients. Paralegal is so important for that. But still, the clients want to hear from the attorneys. You got to follow office procedures for things like making sure we don't represent the wife on a divorce case and the husband on the same divorce case. And you have to really make sure that you're not ever giving advice for those of you who are going to become paralegals. Even something as simple as talking about when somebody might receive their settlement check in the mail can actually be considered giving legal advice at times. So typically when in doubt, just leave it to the attorney to communicate that information to the client. Okay, one of my biggest beefs with practicing law right now is that basically if I talk to anybody about a case, I'm pretty much supposed to send them like a denial letter if I choose not to represent them. This can get kind of ridiculous because you're going to learn that once you become a legal professional, at parties, people just start hitting you up for information. Like, am I supposed to say, okay, I talked to you for 5 seconds at a party, give me your address so I can send you a denial letter? It's not quite that bad, but if I do have a half-hour consultation with somebody, I probably do need to send them a letter saying, hey, I just chose not to take your case. You need to go find somebody else before your statute of limitations is up if you are interested in being served. Okay, how do you avoid unauthorized practice of the case? Unauthorized practice of law? There's a great case from your book. I highly recommend you read it because I'll probably test you on it. But really, this is something that you need to read on your own. Also, just as a reminder, I do put the important chapter review questions to focus on at the end of the chapter to help you start preparing for your midterms and your final. All right, bye for now.